benefit is that if you have a contract between an owner and a PMC or a consultant or engineer or whatever terms you use, the third party to help you supervise the construction by the contractor, and if you have a clause in the contract, in this case, requiring the consultant, the PMC or the engineer, or whatever term you call it, to pay an amount to the owner if the consultant breaches the commitments in the contract, is that clause enforceable? And so that's the question. So in this specific case, the person who raised the comment said that the consultant did not do a good job, the owner is not happy, and in the contract, the owner requires the consultant to pay an amount of compensation equal to the mobilization cost and the monthly payments that the consultant has received so far from the owner. So basically, you have to repay all the money you received, and you have to pay the mobilization cost. And the question is that clause enforceable in arbitration as a matter of Vietnamese law in particular, because this is the law that was chosen to govern the contract in question. So that's the overall background. Anyone's got any question about the background? I just want to make sure everybody follows the question.
Yeah, we follow the question.
Thank you. So I think I'll make maybe 3 or 4 comments. Let's take that one by one. The first comment is not to do with the substance of the matter, but in terms of the approach. I think it's a very serious issue, and no one can give a definite answer based on the contractual clause alone, because you have to read the entire contract in its entirety. I mean, a very important clause you would see normally in this contract is the limitation of liability clause. Very often, the consultant would insist on a clause in the contract limiting its liability to the money it has received, for example, maybe even less. So that's one thing you've got to watch out for. And if you've got that clause, then that would limit the remedies available to the owner. So that's the first thing. Secondly, there are many things that may have happened in practice which may impact on the legal position. So you have to look at all of the happenings, all of the circumstances, all of the correspondence leading to the event to come to conclusion. And thirdly, you've got to hear arguments from both sides as well, right? I mean, now we have the complaint from the owner, but what about the complaint from the consultant? What is its case? So as an arbitrator, we always have to hear both sides before making a decision. So all I'm saying is whatever views you may hear from me or from anyone will not be definite, will not be definitive, because it's totally a very tentative, general comment. And in order to get to a more precise position, you need to sit down with your own lawyer and work very carefully through the issues to get to an outcome. So that's the first comment. I think we need to it's very easy and fun to discuss these things here in a forum like this. But with a specific problem, with a specific case, you really need to get specific legal advice on that specific issue before making the decision. So that's the first comment. The second comment is that you will need, before you answer the question whether you can claim the amount from the consultant, you have to answer the question whether the consultant has breached the obligation or not. Just because the consultant has not done a good job, just because you are not happy with the consultant, does not necessarily mean that there's a breach of contract. Okay? In this example that was given, for example, if you look at the contractual clause requires the consultant to attempt to promote the operations, the work of the contractor. So the obligation is only to attempt to promote, to push the work of the contractor. Now that is a very difficult obligation to determine. what does the consultant have to do to attempt to push the work of the contractor? Picking up the phone, sending a letter, going to the site, what does it do? So because the content of the obligation is difficult to ascertain, it is very difficult to say whether there's been a breach of contract or not. So you have to be very careful. You have to be very, very careful to determine whether there's been a breach of contract or not. So that's my next comment. But assuming there's been a breach of contract, so assuming there's been a breach of contract, assuming there is no clause limiting the liability of the contractor, now the next question is, can we claim all of these amounts from the consultant? The question that was raised is that because this is a penalty, the issue that was raised in the email is that they claim this as a penalty amount from the consultant. And under Vietnamese law, under the commercial law, the penalty amount is limited to 8% of the value of the obligation in question. So the first question is this a penalty or not? Now, in the contract that was given to me, this was not called a penalty, it was called compensation in the contract. So that's a starting point. But that is not the end of the matter, because at the end of the day, I think this is a matter a bit in the gray area in Vietnamese law. I'm sure I'm sure many of you have done some research into this issue. You will know that Vietnamese law is not clear on this point. And therefore, sadly, when you go to an arbitration or even the court, the chance is 50-50. It's all up to the party and the lawyer to convince the tribunal. So if I'm the arbitrator, you have to convince me two things. You have to convince me that Vietnamese law allows the parties to agree on a fixed amount of compensation, which is in the normal contract, you call it an LD amount, liquidated damages. You have to convince me that that is permissible in Vietnamese law. And I think that is not impossible. I mean, it depends on the lawyer, it depends on the party, but I think because the Vietnamese law, the civil code, the commercial law very much promotes the idea of party autonomy. If what you agree is not contrary to fundamental principles of Vietnamese law, that agreement is likely to be supported. Yeah. So I think if you get a good lawyer, the lawyer can persuade the tribunal that the agreement on the compensation is enforceable as a matter of Vietnamese law. This is just an agreement on compensation. And that's what you saw in the contract here. The next issue you have to persuade the tribunal is that this is not a penalty. I don't know why the person who raised the comment kept calling this a penalty amount, even though the contract states that this is compensation. So somewhere in the picture there, the parties are thinking that this is penalty amount. Now it's very important because the contractor may argue, the contractor may argue that even though the contract calls this amount of compensation, the parties actually intended this to be a penalty. It's a question of intention. And there may be letters of correspondence, there may be discussion, there may be recording the compensation. They will try to persuade the tribunal that the word in the contract is actually wrong. The actual intention was that this is a penalty, and that a penalty amount is only limited to 8% under the commercial law. So again, it depends on the evidence. Right? A lot of these, in my experience, actually, a lot of the disputes depend on the evidence of facts. The law is not so unclear. The law, you can sort of get to the bottom of it. You know, it's not so much an issue about the law. The really issue is whether you've got sufficient evidence to show your claim, and whether the contractor has got sufficient evidence to dismiss the claim. And so really you have to. We can sit here and talk about the general principles. Yes, you know, Vietnamese law may allow the parties to be free to agree on compensation, and so on. That's easy to say. But in an actual dispute, the evidence may point the other way. So you really have to look at the evidence. So in summary, let me just go back to the example that was given in the case. I think my first comment in summary is that you really need to sit down and go through all of the documents, the evidence, the entire case, the entire contract to come to a view. Secondly, you have to be very careful with this kind of contract when the actual obligation of the consultant is very vaguely drafted. You know, the obligation is to attempt to do something that is very, very uncertain obligation. Thirdly, you have to convince the tribunal that this matter, this compensation amount, is not a penalty amount. It's only a compensation amount that the parties pre-agree, and that is not contrary to fundamental principles of Vietnamese law. And the evidence actually supports that as well. So as the claimant, in this case, as the owner, I think you do have a number of hurdles, a number of obstacles to overcome. That is not to say it's impossible. You can still do it, but you have to get good lawyers, I think, to start with, and make the case very, very, very strong, because the burden of proof is on the owner. My final comment, and I'm sure you all know about this, is that generally, it's not, at least in the contracts that I have seen, the PMC contract that I have seen so far in my experience, it is not easy for the owner to sue the consultant. Not easy, sadly, because consultant often somehow draft the contract in a way that will get them out of responsibility when it comes, when worse comes to worse. That's just the reality. And however, having said that, if the owner is determined to have a very good contract with the consultant from the start, and you can do it, and consultant, in order to get a high fee, may agree to sign on a very, very strict contract, and they will have to buy a lot of insurance to back it up. That's a matter for them. But you can do it. But I think you would need a contract in very strong terms in order to make the consultant liable for the consequences. You need to be very, very careful. So that is all of my comments so far. I will happily welcome any comments or further questions from the team. I will leave it there for now. Thank you.
Thank you. In Vietnam, it is not that easy to sue the consultant and get them compensating or the fee that the client assumed that he may get back, because the contract between the client and the consultant is strictly operated under the civic law. The civic law states very clearly that if, in case, someone may be entitled to be compensated, there must be a limit of compensation under the construction law up to 12%. And that's it. Given that, okay, you pay them like $1 million, and then if even in case you prove them wrong, they are going to pay you back $120,000 max. There's no way you can get more from the consultant. I fully agree with you that the contract between, the contract between the PMC or even architect to the client must be clearly state the deliverables. The deliverables are very important. There must be the timeline, there must be a report, there must be a drawing, there must be whatever the formula. Given that, if they breach that one, the client may stop and the loss may be prevented in the very early days. Of course, I'm a consultant myself. I don't want to get away from my liability. I try to sort it down, but not all the time. The people can live well for a long time, like 3 years of contract, 5 years contract. Time change, people change.
Thank you. Thank you. I agree with all of that. I agree with all of that. It's not easy to sue the consultant. Also, as the owner, honestly, as the owner, I think oftentimes you have bigger jobs to do than suing the consultant. I mean, things get really bad when you have to sue the consultant. So yes, but it's not easy. But at the same time, as I said before, if you have a very clear, strong contract, it is still possible, but you need a very clear, strong contract to start with. Thank you. Thank you for your comment. Very interesting. Any other comments or questions?
Hello.
Ah, hello, stranger. There you go.
Hello, stranger. I'm about to leave for airport, but I try to stay because I know that a good speaker will come. Hello.
Hello. Good to see you.
By way of background, we know each other. So, but anyway, it's very interesting. I'd like to have some comments before I go for the airport. The first comment that I would like to take to speak upon take on the points that Mr. Dun,
Yes.
Mr. Dun just points out. It's very hard to sue the consultant because the consultant, the delivery, the definition of delivery. Oh, sorry. Hold on. Can you hold on one second? Hello, Wing ơi, chị đang ở conference call chút chị gọi lại em nha. Sorry. It's very hard to sue consultant because the consultant is the one who actually, in their scope of work, they know exactly what is the method of delivery and the quantity, and it's very hard to quantify what is the product of the consultant. And as you said, as you mentioned, Hop, in this particular example, the terms, I don't remember exactly, but the term attempt is so hard to define. What is the attempt? What is the assistant? So in my advice to my clients who is the owner, I always ask them to be fair to the consultant because it is the consultant who make money for the employer by putting all of their effort to deliver the good consultancy. Okay, that leads to my other point. My other point is, what is the drafting intention and drafting technique here? That is the point. I think that you cover all of the good points here. I don't want to repeat, but my comment is, maybe the lawyer, when they do the drafting, what is their intention in that drafting? Do they want to just, like threaten the consultant? Do they want to actually enforce that clause? If they want to threaten the consultant, then it could be interpreted, as a penalty, or they actually want to enforce it. They need to look at the techniques of that. And the other thing that, if a lawyer puts in that clause, I think that there is another thing that you, as the owner, as a client, you may question whether it would backfire or counterproductive, because the communication would be, the indication for this would be the reaction from the consultant. The consultant either can walk away to terminate that and terminate the contract, and then let the owner take the action to sue them, and have the owners to prove the wrongdoing from the consultant. And if they take that commercial action to terminate the contract, the person who actually make loss is the owner, because First of all, the owner needs to find another consultant who will pick up the work. And usually, if you are the lawyer for the consultant, what you would care, because you always have never have the upper hand in the contract negotiation. But what you need to control is you need to control the scope of work, whether it's fitted up, verbal delivery method, and also the copyright. Whenever, if I am the consultant lawyer and I don't have the leverage in negotiation in this contract, I would accept this clause. First of all, because I know that clause will not be disposable because of the unclear interpretation, but I will try to draft the copyright clause in a way that you never can use my work unless you pay me. So in a way, there is way to deal with that. It's a tactical move from the lawyer to the lawyers. So I am the lawyer for consultant. I sometimes take the honest strategy rather than the tactical move. I will talk directly to the lawyer from the other side. I said, if you want to use tactical move, we will have way to deal with it. We will get away with that. But if you don't want that, let's talk about risk allocation, about the enforceability, and there is an example. It is an example, a real example that I don't think I'm good or talented, but I did it, and I did it maybe by luck. There was exactly not exactly the same clause, but there was an unfair contract, one-sided contract that my client, an architect, signed with the owner, and this is a very, very heavy penalty, and the architect, who is a lead consultant in that project, decides that they want to walk away. They wanted to walk away because if they continue this contract, they would have the loss. So yeah, so they want to walk away, and they asked me, how can they walk away? How can they walk away with minimum damage? They didn't ask me to renegotiate the contract. But what I said to them, I look at the contract is really unfair, and I saw drafting history. The drafting history pointed out that it's a one-sided contract, and I told my client, I cannot promise you, but what I can do is I will try to renegotiate this contract clause, this clause. If you let me talk to the group, and then I'll talk to the group. The first thing I asked them is who's going to draft the contract, who already drafted that contract. I don't want to comment on this, but the implication is my client is pulled out. My client is going to pull out, and at this time, the copyright law is on our side. If we pull out, then unless you pay us this amount, we won't release that work for you. And if you don't have that work, you're going to pending the lawsuit, pending the penalty, you're going to have to find another person to continue this contract. So this is your choice. And then I also asked, because there's a negotiator, this is the negotiation, and the owner was there. And I said, if you want that approach, you're going to take this approach. Also, the second point I pointed out to them is, if you go to the court will look into the history, drafting history, and also look into who's drafting that, and then may interpret in favor of the person who has disadvantages. So in such a case, you have the problem legally and commercially. So what are you going to do? Are you going to renegotiate this clause? Are you going to take that approach? We're going to prepared to do that. And after that, funny enough, I'm lucky at that time. They turn around, they say, okay, we negotiate that for, so our client continue with this contract. It was and then after that, the client told me that, oh, actually, so from now on, I can do all of the contract for them. But I told them, this is just my luck, not talented. But that is the tactical move. Yeah. Thanks.
A small question. And excuse me. You said that when you are having a claim, you have to see whether it is a claim or penalty first. As your second point, and you said first that you have to see that. You said that when you have in a claim, first we have to see whether it is a claim or penalty, right? So it's according to my understanding, in civil law countries, penalties allowed, right? Yeah. Then, if it is reasonably applied the penalties, can the court revise it or not?
Thank you for the question. In terms of the concern here, yes, Vietnam, as what you may call a civil law country, recognizes and allows penalty clauses subject to the limit in the law. So this is what the concern is. Yes, you may have a penalty clause, but the maximum amount of penalties is either 8% for commercial transactions or 12% for state-owned projects. So the question is the limit. It's not so much the permissibility. So what the owner wants to recover here is more than the limit of the penalty under the law. They want to recover the entire amount. That's why they have to try to argue that this is not a penalty clause. You have to argue that this is actually a compensation amount, not a penalty clause. And it's not even just a compensation amount, it's a pre-agreed compensation amount. And this is where this Vietnamese law is not so clear. Are you allowed to have a pre-agreed compensation amount? But I think you've got good lawyers, you can still get over it. Does that answer your question?
Yeah, that means in that point, the compensation according to the common law and the penalty according to the civil law is in a same coincided level. Am I right?
No. In the common law world, so you would have damages. Okay, you would have damages, either damages at large, unquantified, or damages pre-agreed in terms of liquidated damages. In addition, you may still have a penalty clause, which is not recognized under common law, but if the parties want to have it in a contract, then you can still have a penalty clause in the contract, not recognized under common law. So you have those three kind of clauses in the common law contract. In the civil law world, it's pretty much similar, really, and you have compensation. So compensation is equal to damages in the common law world. And then separately, you have a penalty clause, which is recognized in civil law countries, and in the Vietnamese context, recognized subject to a cap.
Thank you very much.
Thank you. Any other questions?
One more question. Okay. Sorry, one more question. And you said that party autonomy. Is it again a common law principle? Party autonomy is. I know that, and I know that party autonomy is somewhat restricted in civil law countries. Is it applicable in Vietnam also?
Yes, the concept of the freedom of contract is widely recognized under Vietnamese law, but of course always subject to mandatory provisions of the law.
Right.
So the issue then is, if the law says that if you breach the contract, you have to pay for the actual damage, does that mean that you are not allowed to pre-agree the amount of compensation? That's the question. That's the tricky question.
For example, parties would agree a pre-agreed amount which is actually smaller than the actual damage. According to the party autonomy, you have agreed a lower amount, but when you go to a civil law principle, can the innocent party claim the actual damage since we are having pre-agreed amount in the civil law? I mean the Vietnam.
So
Can. Okay, thank you.
no, sorry. Can I? No. You will never get such a definite answer from a lawyer. The answer is that this is an unclear area in Vietnamese law, and the innocent party, as you say, will try to seek the actual amount of damage, and in order to do so, they have to argue that Vietnamese law does not allow the pre-agreed amount of the pre-agreed compensation amount. So they have to make that argument. Now, whether they will succeed or not is an open question.
Okay.
I don't think so. Here's my comment. Okay, we can hide. We can play the trick. We can hide the pre-agreed compensation somewhere in the contract. And when the both parties enter the contract, they are very happily take a hand, going on, we live forever. But when they go to the court may justify, based on Vietnamese law, that that clause may be out of the sand because it's a hidden, we say, damages article, and they may justify, say, look, guy, no matter how you try to avoid, it is a damages, it is a compensation, or it is the penalties, the same meaning. And then you have to come back to the penalties resolution under the civic laws. I have to admit that under the common laws, the lawyer has a voice, but not in this country. So please be careful. I rather recommend you to get the way out from the early sense than try to seek the compensation from the party. Even we are a PMC, we are seeking the compensation from the client. We rather stop somewhere, not losing our time and money, than arguing with them to pursue something that we are not going to see in the future. Yeah, I understand. Oh, sorry, the private question to Dr. Kun, right? Under the common law, you can seek for unlimited. You can seek unlimited compensation. Am I right?
So is that a question to me?
Yes.
So can you repeat the question?
My question is that under the common laws, the compensation under the contract can be unlimited amount, right? Agree amount, to say.
Yeah, it can be pre-agreed. You can pre-agree a compensation amount.
Let's make it easy. Okay, you are the client. I'm the project management company. My contract to you, like $100,000, and I agree with you that I can pay you back $100,000 if I fail to deliver something. Can I? Is this fighting?
So just to make sure I understand your example, so you have a contract between the BMC and the owner, and the total value of the contract is $100,000.
Yes.
And there is an agreement that if the consultant breaches the contract, the consultant has to repay the entire $100,000.
Yes, exactly.
The question is that enforceable under common law?
Yes.
Okay, I think the answer depends on whether the court sees this clause as a compensation agreement or a penalty agreement, right? And one can argue that this is a penalty agreement because even if the clause is drafted very widely, so if the consultant commits a very small breach, you still have to pay the entire amount. Now that is an indication that the level of compensation is not proportionate to the nature of the breach. And so if you have a very widely drafted compensation clause like that, it is possible for the court to say this is not compensation, this is actually a penalty clause, therefore it's invalid under common law. On the other hand, if the contract says that if the consultant commits some serious breaches of the contract, such as failing to do any work, such as giving seriously wrong instruction to the contract, something very serious, then the consultant has to repay all the money. That may be okay, because that is no longer a penalty clause, it's actually compensation.
Yeah.
So again, it depends on the entire contract and these entire circumstances. You know, it's difficult to give one definitive answer, but it really depends on how do you view the clause. Is it a penalty clause or is it a compensation clause? Doesn't matter what you call it. The name is irrelevant. Does that answer the question? Any other questions?
Excuse me, Hop. Maybe
Yes.
maybe you can explain a little bit more or elaborate a little bit more about the reasonable test of in the common law about the estimated damages, because that may prove that whether this clause has the punitive nature or not. If the punitive nature, then unenforceable. If this is properly estimated, and that was supposed to the proposition. Secondly, my assumption in this original example is they would the owner would like to, under the law, the owner would like to see it as not the pre-estimate clause damages, because under Vietnam law the pre-estimate damages is very difficult to prove to be enforceable. They would prove it is the penalty because the law allows you to have both compensation and penalty, and the penalty would be stated clearly in the contract. Under that Vietnamese law provision, if I were a lawyer from the owner, I would say that this is the penalty rather than the estimate damages, because then they can also ask for. Remember, the person who asked the question also raised the question whether they still have, in addition to that clause, they can still have the compensation. The compensation then needs to be proved by the causation, by the damages, and by the contributory fault. So all of that we need to be given together. So maybe for the benefit of the group, maybe you can elaborate on the reasonable test.
Yes, thank you, Jing. I think you have said it all, and this is what I also alluded to when I was saying that if the amount is not proportionate to the nature of the breach, then likely the court will see that this is not compensation, it is penalty. So if you agree that the consultant has to repay the entire contract amount, even for a very small trivial breach, so there's no equality or commensurate sort of equality between the amount and the breach, then likely it is a punitive amount, as Jin was saying, and the court may strike it down. So it all depends on the context. You know what's happening. It as I was saying at the beginning, a lot of this depends on what is the actual breach, what is the actual amount that has been claimed, and what is the relevant surrounding circumstances.
Thank you, Hop.
Did you have any question? Hello anh.
Oh, hi.
Okay. I just have some comments on this particular case because the drafter in favor of the lawyer trying to push the risk on the consultant. Saying he asked the consultant to make every effort to ensure that the schedule is on time. If the contractor fails to meet the schedule, then the client, the employer, will have a variety of options to do. So we have to come back to our particular case. The lawyer, I think, draft and provide too many different but contractually options in that clause. Let's say he provided that if the contractor fails to meet the schedule, then the consultant will no longer to be paid. He must bear himself for the continuing the project until the end. He has to compensate again the mobilizations and the monthly payment and etc. Thus, all of those provided are contradictory to each other. I give you an example is that whenever the employer terminates the contract, how can he claim back the consultant to provide the service? Because the contract is terminated. So no longer a contract between the employer and the consultant. How can he provide the service? Now again, once he, how can I say, he paid all the money to ensure that the project will come to an end, to complete the project. How can he reimburse the money he received to the client? Because he already bear himself for the continuing the project. So the first question is, as I agree with Jing, is, and we have to come back with the lawyer to see what is really intensive. Is it the compensation or penalty? We have to define, if it's a compensation, then we have to define the suitable sequence. But if it's a penalty, then we have to come up with the law on construction now. It's clearly saying that the construction contract is a civil contract. It's not a commercial contract. How can we ask him to compensate? Not penalize. How can we penalize for failing to meet the schedule? So my first issue is we have to come up again to ensure what the drafter intention is. His intention is to provide for compensations, damage, or for the penalty. That is the first question. The second question is about what if the consultant agree on it? Because one of our members saying that yes, the consultant agree on that term, and we have to read through that particular clause. The clauses only provides that in order for the employer to trigger the clause is the contractor fails to meet the schedule. So the schedule is the trigger. Whenever the contractor fails to meet the schedule, and then the client is entitled to claim for this, to rely on this to claim. So the second question is it possible for the client to use as this clause as a compensation or penalty? Because clearly this penalty here is not applicable. The construction contract is a civil contract. We are unable to use the commercial contract like 8% of the commercial contract. Yeah, so that's it. Two concern from me on my side. That's yes, agreeing that no clear answer to our member question. Is it possible or impossible? But somehow, in my personal judgment, this law will not be able to apply in practice because it's contradictory. It imposes unreasonable obligations on the project management company, and thus, because the project management company provides his service, he are unable to liable for all the damages. As I said, the damages at last. No one knows what exactly the damages. How can we ask him to reimburse it? So my personal judgment is this clause is somehow it's not. It might not be invalid, but this might not be possible. Yeah. What is your opinion?
Okay, I think let's. I think you've raised several interesting issues in the question, so let's try and take them one by one. If I forget something, remind me. But my first comment is, just because something looks unreasonable at the moment does not necessarily mean that it's not a binding contract.
Yes,
right?
sure.
And so that's a starting point, because I think if you try to argue and I've just had a recent case in which the parties agree on a particular coefficient in the formula, and then later on the coefficient proved to be unreasonable, when you say in one party's view, and the party tried to say the formula is very unreasonable, but that is not sufficient for the tribunal to strike out the contract. You agree to something in the contract. You cannot get out of it by saying it's unreasonable only. It's got to be something more than that. So that's a starting point. Once you have signed a contract, then you're expected to follow it, unless you show something illegal, unfair, something more than just unreasonable, if you know what I'm saying, something bigger than that. And so that's a starting point. The second point, I think you're saying how in practice this clause may not work, and I agree with you that the clause that was given in the example has a number of problems in it, and I also at least a number of options and remedies that you pointed out: terminate the contract, continue, pay the money. I mean, lots of stuff in there, and some of it may not work, but don't forget some other part may still work even with the same clause. And if you're a clever party, a clever lawyer, you can still separate the bad parts from the good part and use the good parts to make it work. Right? So it very much depends on what actually happens and the case at hand. So if in this case, for example, if the owner says that the consultant has breached the contract, and the owner says, therefore I want to terminate it. That's all I want to do. I want to terminate it. Then certainly you can, under that clause, you can terminate the contract if you show that the contractor, the consultant, has breached the contract. But if you go further and you say, I want to terminate, but at the same time I want to force the consultant to continue to work, and thirdly, I want to get all the money back at the same time. So maybe if you go too far, then maybe it will not work. Right? So it all depends on what you want to do. The clause gives you a number of things, and it depends on what you want to do. And so I think here is the distinction between legal advice and legal recommendation. Yeah. On the one hand, you may have legal advice that the clause is impossible, but on the other hand, the lawyers may still recommend that, but go and do it anyway, because maybe you'll get it. You never know. So there's a difference between legal advice and legal recommendation there. And the third point that you raised in relation to the distinction between penalty and compensation. And this is a civil contract under the construction law, and therefore, what about the penalty clause? But I just wanted to mention that even in the civil code, it allows for penalty clauses, right? Even in the civil code, not only in the commercial law, even in the civil code. So you have to look at that as well. And some people may even say that the provision on penalty in the civil code is more liberal than the provision on penalty in the commercial law. However, there's a risk that the court may apply both the civil code and the commercial law to say that if you agree on if you have a penalty amount, it has to be limited by 12% or 8% or whatever the limit is, and that's it. And also, the tricky point here is that the 8% limit is the 8% of the value of the obligation that is breached. It's not the 8% of the entire contract. 8% of the actual obligation that is breached. So what is that? So it brings in a lot of tricky questions. And the law is full of ambiguities. And if you bring a legal action, there's going to be a number of risks. But again, having said all that, that is the legal advice. But the legal recommendation may still be go and sue it, go and claim. If you're the owner, make the claim. Don't worry. What do you have to lose? Nothing to lose. Make it big. Make a big case. Write a strong letter. It's okay. Consultants will not like that. Contractor will not like that. But if you're the lawyer for the owner, you've got nothing to lose. What's the big deal? The law is unclear, but it doesn't matter. Just go for it. You may win. And so it all depends. So have I missed any point in your questions?
No.
Thank you.
Okay. I just correct us. The first part, I agree with you that we are unable to rely on the merits of the contract to say this is a non-binding contract. I agree that this is a binding contract. It's unable to say no, it's invalid. It's still valid to some extent. That's practical or not.